go.
Bydgoszcz. Yes. In Bydgoszcz.
In Bydgoszcz, yes, and she's dealing there with civil cases, and she will, after saying a few words about what's going on in Poland concerning our topic, she will treat the topic, does the involvement of judges in the search for amicable solutions contribute to their well-being? Mrs. Marcelowska, please, you have the floor.
Thank you very much for inviting me. Thank you very much for giving
Mogę mówić.
as a first person. But about the Polish situation, we agreed with my colleague Jakub that he will take the floor and takes 2 minutes, which was given to us for 4 minutes, because 2 minutes for each speaker, and he will present the situation in Polish judiciary. I prepared a topic about does involvement of judges in the search for amicable solution contribute to their well-being, and I could present the paper right now if you wish. Or if you wish to give the floor someone who will talk about the situation in the countries first, I will give the floor to the others. So please make decision about whether I should present the topic right now, or I will present as a following person in this day.
No, please go ahead, go on.
Right, okay. Thank you very much. Thank you. Because there was given only 12 minutes, I tried to be as short as possible about this topic and not to give the not to present the full situation concerning this topic. I prepared for myself papers, and please be kind and listen what I prepared about this topic, and then about the question, if you have any, you feel free to ask. Judiciary these days is full of caseloads, and judges are overloaded by stressful proceedings. This leads us to increasing role of promotion of alternative dispute resolution methods. The involvement of judges in the search for amicable solution presents a compelling but complex issue. The most important question is whether the involvement of judges in the search for amicable solution contributes to their well-being, having in mind their obligation to impartiality and independency. The immediate pressures of settlement facilitation can be taxing. A deeper analysis reveals that this involvement can foster a sense of efficiency, purpose, and mastery, offering a powerful antidote to the burnout and moral injury very often connected to adversarial roles. First of all, there are so many stresses over the traditional adversarial system. Judges are consistently exposed to human conflict, trauma, and the necessity of making consequential but often painful decisions. The core judicial function involves constant, high-stakes decision-making. Each judgment carries significant weight, impacting livelihoods, liberties, and family relationships. This leads to decision fatigue, a psychological phenomenon where the quality of decision deteriorates after a long session of making them. Furthermore, the knowledge of the consequence load creates a persistent cognitive and emotional burden. Judges must perpetually suppress personal bias and emotion to maintain objective impartiality. The imperative for impartiality often necessitates profound professional and personal isolation. Judges must maintain a distance from litigants, the bar, and even the public to avoid any appearance of impropriety. This detachment, while necessary for the system's integrity, can lead to a sense of professional loneliness. The judge's role often demands a stoic exterior, making it difficult to process the secondary trauma absorbed from hearing devastating testimony, leading to an internalization of stress and harms of well-being. Across jurisdiction, judges face overwhelming case volumes and relentless time pressures. This administrative burden often overshadows the intellectual and ethical demands of the role. the emphasis shifts from deliberation to disposition, reducing the judge's work to a transactional processing of files. This environment is a classic recipe for burnout, characterized by emotional exhaustion, depersonalization, and a reduced sense of the personal accomplishment. The answer for above-mentioned stress might be a see judge as a facilitator of the settlement. The movement toward judicial involvement in settlement negotiation represents a fundamental shift in professional identity from impartial adjudicator to active problem solver. Although in Polish judicial system, active judges cannot be mediators as such, but they can encourage parties to make a settlement or to drive the case to professional mediator who actively guides the parties toward a mutual acceptable resolution. The recent changes of civil procedures in Poland allows judges, by using their authority and expertise, to evaluate the case's strengths and weaknesses. The judge presides over structured negotiation, pushing the parties to confront the risk of trial, provides a non-binding objective assessment of the case early in the litigation process to encourage realistic settlement talks. This proactive stance offers potential ways for enhanced well-being by directly addressing some of the core stresses to adversarial model. Talking about positive contributions to judicial well-being, we must say that the proactive involvement in seeking amicable solution can significantly and positively affect judicial well-being through several key mechanisms. The adversarial system often leaves judges feeling that they are merely choosing a winner and a loser, resulting in at least one dissatisfied party and the extended doubts about whether the best outcome was achieved. In contrast, facilitating a settlement provides a universally accepted win-win solution. Successfully guiding parties out of fortified conflict toward mutual consensus provides a powerful sense of professional accomplishment. The judge moves from being an arbiter of past complaints to a shaper of the future peace. This shift replaces the stress of imposition with the satisfaction of facilitation. Unlike a complex trial, where the success is simply the delivery of a judgment, a mediated settlement offers a clear, measurable achievement, such as the discontinuation of the litigation. This positive feedback loop is crucial for better moral victory and combating the feelings of fed up of overloaded docket. A judge's well-being is often linked to the sense of professional mastery, which ADR involvement directly enhances. The adversarial system frequently forces judges to apply strict legal principles, even when the outcome appears morally or equitably unsatisfying. This creates cognitive emotional dissonance, a major contributor to moral injury. Amicable solutions allow judges to consider the holistic needs of the parties, moving beyond the narrow boundaries of the legal remedy. A negotiated settlement can incorporate creative, practical, and non-legal terms that truly addresses the underlying causes of the dispute. By helping parties achieve a more equitable or satisfactory outcome, judges can align their professional actions with their internal desire for justice and fairness. A negotiated agreement arrived at by the parties themselves often leads to greater consensus and reduces costly and time-consuming appeals. For the judge, this means less second-guessing, fewer appellate reversals, a significant source of judicial stress, and a cleaner final disposition of the case, which directly contributes to a mental peace. The settlement creates more human connection. During encouraging to agreement, the judge often must exercise empathy to understand the parties' true interest, not just their stated legal position. This controlled, purposeful use of emotional intelligence is far less taxing than the constant suppression of emotion required in the courtroom. It allows the judge to connect with the purpose of their work, helping real people in a direct, meaningful way. Historically, judges were often seen as wise counselors. The settlement role allows them to temporarily reclaim this aspect, utilizing their wisdom and experience to guide others. While the benefits are significant, the involvement of judges in settlement is not without its own set of unique stressors that must be acknowledged and managed to ensure a net positive effect on well-being. The most significant tension is the need to constantly switch roles from a neutral, impartial decision maker to an active, persuasive settlement facilitator, and potentially back again if negotiations fail. These role changes can create ethical anxiety for the judge. The worry about whether their settlement efforts might compromise their impartiality, should the case proceed to trial, or whether they inappropriately exert judicial authority to coerce a settlement. This anxiety, rooted in maintaining the integrity of the judicial function, is a substantial mental burden. Time spent in mediation is time taken away from reading briefs, writing opinions, and presiding over trials. If settlements fail, the judge has potentially wasted significant effort in empowering the existing stress from case backlog. Furthermore, an overloaded judge might feel an intense pressure to settle any way possible to clear the docket. While the outcome is positive, the process of high-stakes negotiation can be emotionally draining. Judges must absorb the emotional output of two highly conflicted parties and their counsel acting as a conflict sink. The solution lies in providing judges with access to solid well-being programs, peer support networks, and mandatory training in stress management and techniques specific to the emotionally charged environment of mediation. In summary, we must say that the shift toward amicable solution by offering judges a path to more fulfilling, effective, and holistic conflict resolution serves as a powerful preventative measure against judicial distress. It allows them to feel like constructive agent of change rather than mere processor of inevitable conflict. This renewed sense of purpose derived from helping citizens actively shape their own outcomes is a powerful driver for long-term professional satisfaction and well-being. The answer for the question whether the involvement of judges in the search for amicable solution contribute to their well-being is with no doubt yes. While the process introduces new challenges, primarily the anxiety of role ambiguity and the potential for the time drain, these are vastly outweighed by the benefits of increased efficiency, reduced moral injury, and a deeper sense of the professional purpose. The ability to facilitate a lasting, mutually acceptable resolution acts as a psychological balm, counteracting the relentless emotional labor and decision fatigue of the adversarial courtroom. By embracing the expanded role, the judiciary not only improves the justice for the litigants, but also actively creates more rewarding, sustainable, and less emotionally taxing professional life for its most critical members. The path to judicial well-being, therefore, increasingly runs through the challenging but finally gratifying terrain of constructive conflict resolution. That was my paper. Thank you very much for your attention. If you have any question, I will be very happy to answer.
Thank you very much. Dziękuję bardzo.
Dziękuję.
Thank you. I will now give the floor to your colleague, Mr. Jakub Petkiewicz. Sorry for the pronunciation of Poland. He is judge at the District Court Lublin Zakład in Lublin, in Poland. He's a deputy head of the Labor and Social Insurance Division. And he will deal with the following question. Under what conditions will amicable justice be able to ensure the protection of fundamental rights, and in particular, guarantee compliance with Article 47 of the Charter of Fundamental Rights of the European Union, equivalent to contentious justice. Mr. Petkiewicz, the floor is yours. And if you can tell us some words about the Polish system of mediation, it would be nice.
So just 2 minutes about the current situation of amicable justice in Poland. The Polish regulations on the civil procedure have long imposed on a judge a general duty to strive for amicable settlement, yet they still provide rather limited and timid tools for that purpose. An important instrument introduced in 2019 is the so-called preparatory hearing, which serves to plan the trial, particularly with regard to taking of evidence, but it takes place in a less formal manner than a full court hearing. So it is a good opportunity to encourage the parties to reach settlement, which often happens. It is important to note, however, that this hearing is conducted by the judge who will adjudicate the case. Another interesting thing, perhaps the most interesting, is that the Code of Civil Procedure also provides for the so-called informational meeting, ADR information meeting for the parties. It might be conducted by a judge, a mediator, or a court clerk. It seems that the legislator had just one thing in mind. It was meant to be a purely informational meeting. However, many of my colleagues use this tool in a creative way. The meeting may be conducted by a judge other than the one who will hear the case. So thus, a judge may act as a conciliator and encourage parties to settle. They're often willing to admit facts they would never admit for a judge who is actually going to hear the case. Plus, it's free, unlike mediation, and the authority of a judge may facilitate the conclusion of a settlement. So, judge as a conciliator, this is obviously a solution known in many countries. And it is thanks to many Polish judges that it has appeared in Poland, but as you can see, it had to be brought through the back door, kind of. A thing which I believe is important is that next year judges will obtain a tool for motivating parties to participate in mediation. Until now, there has been a provision allowing the court to impose litigation costs on a party who unreasonably refused to mediate. But the provision was very unclear and therefore almost never applied. The new version will be more forceful and hopefully more effective. So as you can see, the Polish legislator is slowly but steadily recognizing the need for more decisive encouragement of the parties to use various forms of ADR, which remains a big challenge in Poland. Moving on to my main topic. So yes, the topic was to be under what conditions will amicable justice be able to ensure the same level of protection of fundamental rights equivalent to contentious justice, especially in compliance with Article 47. So just a reminder, it follows from Article 47 of the Charter, inter alia, that everyone whose rights and freedoms guaranteed by the law of the Union are violated has the right to an effective remedy before a tribunal, to a fair and public hearing within a reasonable time by an independent and impartial tribunal previously established by law. Now, as you all know, this basically corresponds to Article 6, Paragraph 1 of the European Convention on Human Rights. But let's try to make the initial question simpler. So can amicable justice ensure the protection of fundamental rights equivalent to contentious justice? A good lunchtime seminar should start with a little earthquake. So here are my personal views. Can it? No, it can't. Does it have to? It doesn't. And should it? Well, it shouldn't. So it can't, because most forms of ADR do not take place before a tribunal, And even if a judge is involved, his or her role is limited and does not consist in any form of judging. And usually, there's no form of hearing, and certainly it is not public. Secondly, it doesn't have to meet the same standards because the requirements set forth in the Charter and in the Convention apply to court proceedings only, and neither the Convention nor the Charter requires that every dispute should be resolved only through a court trial, even if a party initially decided to bring an action before a tribunal. And last but not least, the right of access to court is not an absolute one. Finally, it shouldn't, because the institutional and procedural guarantees listed in the Charter and the Convention come at a cost. And the parties, referring to ADR, waive those guarantees for other advantages. They waive rigid procedural framework for flexibility. They waive public hearing for confidentiality. They also waive reasonable time for really short time, and a judgment by an independent and impartial tribunal for a solution that they both shape. So does this mean that anything goes in amicable justice? Does it have anything to do with fundamental rights? Well, it certainly does. Especially if we deal with amicable settlement as a judge. This means that a party initially decided to seek remedy before a tribunal, and they have been convinced by us or by the legislator to waive this right. So amicable justice can in fact be seen as a limitation of the right to court. Thus, according to Article 52, paragraph 1 of the Charter, any such limitation has to respect the essence of the right, as well as the principle of proportionality. It also has to be necessary and meet objectives of general interest recognized by the Union or protect the rights and freedoms of others. Yet, the law of the Union clearly allows for such limitation. Directive on certain aspects of mediation in civil and commercial matters in Article 5, paragraph 2, permits national legislation that makes mediation compulsory or subject to incentives or sanctions, as long as this does not prevent the parties from exercising the right of access to the judicial system. Directive on consumer ADR contains the same provision in its Article 1, and we find some more interesting details in the Article 9, paragraph 2 of this directive, whereby the parties should have the possibility of withdrawing from ADR procedure at any time, and they should be informed of that right before the procedure. In the Menini and Rampanelli case, the Court of Justice stated that under the said directive, a recourse to mediation can even be a condition for the admissibility of the legal proceedings. However, national legislation may not require parties to demonstrate the existence of a valid reason if they want to withdraw from a mediation procedure. Now, under the Article 52, paragraph 3 of the Charter, the rights it contains should be understood in the same way as in the European Convention on Human Rights. Thus, we can also refer to Strasbourg jurisprudence. European courts of human rights held in the case Momcilovic versus Croatia that a settlement attempt may be a condition for admissibility of a civil action. In turn, in the case Dever, I hope I get that right, versus Belgium, it held in turn that a party should be allowed to challenge a settlement that has barred court proceedings. So these are important limits for amicable justice. Any form of ADR actually, but we can easily see that they mostly depend on the legislation. So the question is, what can an individual judge do to make sure that the essence of the right to court is respected when parties are referred to any form of ADR? So there is a lot to do for a judge, depending on the stage of the proceedings. Before the amicable settlement even starts, if it's a judge decision to refer the parties to any form of ADR, we should remember to provide them with complete and understandable information on consequences of both accepting and rejecting such referral and of their rights. Now it is obvious that we want to convince the parties to mediate by tricks or threats, but we should not cross the thin line of threats at this stage. Now, during the amicable settlement procedure, if a judge acts as a conciliator or mediator, we can provide the parties with some form of fair hearing. And it is our own responsibility to act in an independent. This is the task of a third party, especially a mediator. We should come back to stage one, that is before the ADR is initiated. Because a key element in mediation is to make sure that it is conducted by skilled and ethical mediators, especially if a judge referred the parties to mediation, we as judges partly take responsibility for its quality. This is obviously true if a judge has any influence on the choice of mediator. And now, after the amicable settlement procedure is over, this is perhaps the moment, I believe, when a judge has the biggest role to play in terms of respecting the essence of the right to court. If amicable settlement attempt has failed, especially because a party refused to participate, then a judge often has the possibility to impose negative consequences on the refusing party, especially in terms of costs. I believe this is right, and I do it sometimes. But still, this should be done after a careful consideration of a party's reason for refusal and not as an automatic punishment. This is also a moment when we should be particularly careful not to display any sign of partiality. Then, if the amicable settlement attempt has resulted in an agreement, now everything seems easy because, well, that was just the plan. And at this stage, the agreement is subject to judicial control, which should obviously be independent and impartial. Yet such control is usually done without a full hearing, and the scope of such control might be problematic, especially in consumer or employment cases, so cases involved weaker protected parties. The question is how much we should trust the parties and the mediator, or how much we should investigate into all the facts of the case to check whether the agreement is lawful. I personally believe that the scope of such control should be limited, and the parties' agreement should be questioned by a tribunal only in exceptional cases. Now we come back to the beginning, because we refer parties to any form of ADR because we trust that they know what's best for them. They accept such referral because they finally share this view. And if all is played well before and during the amicable settlement attempt, that is on the first stages, we usually do not have to worry about the outcome. And yes, these are my views on the relation between amicable justice and fundamental rights. Thank you.
Thank you very much. Dziękuję bardzo. Now the word is to Mr. Timothy Powell from the UK. He's a regional tribunal judge of the first-tier tribunal, property chamber, residential property. Mr. Powell, dear Tim, the floor is yours.
We don't hear you.
No.
We don't hear you.
Now, can you hear me?
Yes, perfect.
Okay, thank you. So today I'm going to talk about the development of judicial mediation in England and Wales and say why they strengthen the interests of both of the parties and judicial efficiency. And I'm going to focus on landlord and tenant disputes where ongoing relationships make mediation especially valuable. So the development of mediation in England, judicial mediation in England and Wales, we have a regular use of external mediation in civil and family courts. And in the civil courts, for example, at the moment, there's a 2-year pilot where all small claims valued at less than £10,000, which is about 12,000 euros, they're automatically referred to mediation. But this is external. It's not carried out by the judge. Judicial mediation, which is amicable settlement by judges, is found only in specialist tribunals, the employment tribunal and the property tribunal that we call the property chamber. So the employment tribunal began judicial mediation in 2009, and 2 years ago there was a presidential guidance to judges to encourage them to put cases forward to mediation. This could be through an external service that is known in England as ACAS. But there were 3 options for judges to become involved in mediation. One was judicial mediation for cases that were 3 days or more, and this was the standard facilitative mediation where the judge helps the parties reach their own agreement. Then there's judicial assessment, which is evaluative, which is more like conciliation, telling the parties what the judge thinks. And then they have dispute resolution appointments, which is mostly for long cases, which again is evaluative. And their dispute resolution appointments are usually by video or by telephone, but they can be in person. They use specially trained mediation judges, and they last about 2 to 3 hours. In the property chamber where I work, we started judicial mediation in 2006. It's a free service. It's usually half a day in person or by video. We use judicial mediators, which for us means judges, and it also means non-legal members who are often professionals such as surveyors. And they're either trained externally to the tribunal or internally, and it's a facilitative mediation. And we encourage mediation as soon after the case is received as we possibly can. We've produced a video for the public to tell them about mediation, and after my talk I will put a link into the chat so anybody can look at it if they wish. And 2 years ago in our southern region, we started conciliation hearings, which are evaluative, where the judge will tell the parties what he thinks about, or she thinks about, the strengths and weaknesses of their case. And the key drivers for development is the pressure on our resources as a tribunal. We need to reduce backlogs. We recognize that mediation and conciliation is cost effective. It preserves relationships, and we have integrated it into our procedures, and there's a general cultural shift towards consensual resolution. So the topic I've been asked to talk about is whether the amicable office of the judge, that's judicial mediation and conciliation, do they pursue the goal of humanity or the goal of judicial efficiency? And the short answer is that these are not really alternatives. Mediation, conciliation benefit both the interests of the parties, which is the goal of humanity, and the goal of judicial efficiency. If we look at the interests of the parties, I think we have to ask ourselves, in every case, what do the parties most want? And what they want is a speedy resolution of their dispute at a reasonable cost. And that means a cost in terms of effort or money. And we all know we know that litigation doesn't deliver that, but mediation and conciliation can. And the features of mediation, that it's voluntary, non-binding, it's consensual, it's without prejudice, these all create the freedom for the judge, which, as I said, can include non-legal members in our tribunal, to explore options. So mediation empowers the parties. They keep control over outcomes rather than have us as judges impose them. They can agree on outcomes that are far beyond what a court or tribunal can impose. It reduces stress and legal costs, and in my sphere, particularly landlord and tenant, it can preserve relationships. So I want to give some examples. First of all, terminology. In England and Wales, the owner of a flat or an apartment, we call them the tenant, and the owner of the building itself is the landlord. And many disputes arise when landlords provide services to tenants and they refuse to pay for them. So from my experience, the mediation that I did was a landlord did external decoration of a whole block of flats. And the tenants, that's the flat owners, they refused to pay because the work was poor. And so the claim began in the tribunal. And it was thousands, tens of thousands of pounds. And at mediation, the landlord agreed, firstly, to reduce the costs, and secondly, to recall the builder to do the work again at no extra cost. Now, that was an outcome that the tribunal could not order, but it is exactly what the tenants wanted to happen. And a second example comes from a colleague of mine who is a mediator. She dealt with a dispute between two companies about the renewal of a business lease for a shop in a prime central London location. And there was a legal dispute. Was the application for a new shop out of time? And there were court proceedings, and it went to mediation. And during the mediation, the mediator asked the tenant, well, what do you really want? What's your true aspiration? And the tenant wanted to stay in this fabulous location, but also would love to buy the property. And with consent, this mediation over a legal issue before the court turned into a sale negotiation. And the property was sold, the problem went away, the interests and needs of both sides were met, costs and risk were eliminated. So those were the parties' interests. What about judicial efficiency? Well, caseload management, it's the first speaker we've heard about the overload of judges. Successful mediation removes cases from hearing lists and it frees up judicial time. Judges don't have to write decisions, and that saves a lot of time as well. But I think it's the speed of dispute resolution that is key here. Mediation resolves disputes literally in hours, not months or years. And as the second speaker mentioned, we also have rules, tribunal rules and court rules that promote proportionality and cost effectiveness through mediation. And giving mediation in this way meets those requirements. From a landlord and tenant perspective, there is always an ongoing relationship. So unlike a one-time dispute, often before the courts, landlords and tenants continue interacting. And mediation improves communication between them. It can reduce hostility and it can avoid future litigation. So another example, a mediation I did, was where the relationship between a landlord and a tenant had broken down. For years, the tenant had disputed service charge costs, hundreds of hours of work and thousands of pages of documents had been involved. And 6 weeks before trial, we had a mediation. And in 10 minutes, the tenant explained to the landlord what the problems were. And the landlord said after that 10 minutes that it was the first time in 3 years of dispute he had understood what the issues were. The first time he'd understood. And at once, the landlord started suggesting solutions. And within 2 hours, the whole dispute, years of dispute, was settled and a 2-day hearing was avoided. But the most important thing was that their relationship had been repaired for the future. So the practical benefits of having judges do mediation, it means that the mediator has knowledge of the underlying law, and this ensures a real focus on the issues that the parties have brought. It inspires confidence. And we asked in our chamber what judges thought about mediation, about doing it. And we had roughly 56 mediators in the property chamber. And 80% of them said that their mediations resulted in a full or a partial settlement. They thought remote mediations by video or by telephone were very effective, and they reported high satisfaction from the parties for themselves and a significant saving in time. So just to give you some statistics, since we started mediation, property judges have conducted over 1,000 mediations with a success rate of about 70% and a net saving of more than £500,000 in tribunal costs. And even more impressive in the employment tribunal, which is bigger. Excuse me. So timer. So I've just come to the end of my time, but I've nearly finished. Even more impressive, in the tribunal, the employment tribunal, which is a bigger tribunal, in 14 years, judges have conducted more than 8,000 mediations with a similar success rate, and they estimate they have saved 22,000 sitting days. So that's a huge saving. So to finish and to summarize, judicial mediation and conciliation are not procedural alternatives. They represent, in my view, a cultural shift towards collaborative justice. They balance efficiency with fairness, preserving relationships where they matter most. And they benefit, in my view, both the goal of humanity, parties' interests, and the goal of judicial efficiency. Thank you.
Thank you so much.
Thank you very much for this impressive results. I would like to now introduce Mrs. Dalia Vazariene. She is judge of the Supreme Court of Lithuania, court mediator and representative of the GEMME Lithuania section. She will tell us if the development of amicable justice can strengthen citizens' confidence in the judicial institution and the rule of law.
Good afternoon, everyone. Can you hear me?
Yes, we can.
Okay, wonderful. So thank you very much for inviting me and letting me share my insights on this topic. And as all experts who spoke before, I will share some information about Lithuanian experience in mediation. Starting with that Lithuania is a state not typically associated with the long-standing traditions of mediation. Nonetheless, over the past 20 years, a steady and somewhat unexpected development has taken place in many respects against initial expectations. It began in 2005 with a modest pilot project launched without a dedicated budget, without an institutional structure behind it, and without assurance that either the judiciary or society would support it. A small group of judges, academics, and practitioners asked themselves whether courts could incorporate alongside adversarial procedures dialogue-orientated and restorative approaches. And even more, a fundamental question was whether our legal culture was prepared for such a shift. What started as an experiment has evolved into a stable and broadly accepted practice. Today, nearly 1 of 5 judges in Lithuania, approximately 18 to 19%, is trained as a court mediator, judicial mediator, judge who mediates. For a small jurisdiction, this is a quite significant development, as we counted as such. More importantly, mediation is no longer seen as an external instrument added onto the judicial process. It has become a method integrated into judicial reasoning, communication, and professional identity. Mediation has also become more widely used. In 2024, around 5% of civil and some more narrow extent administrative cases entered mediation. Also, this percentage may appear modest. Growth achieved through voluntary use rather than institutional imposition is meaningful. Nearly half of these mediations, about 48%.
Oui, je vais sortir et je reviens dans un quart d'heure, ça va? Ok, très bien, merci beaucoup.
Sorry, Mrs. Vazariene, we cannot hear you.
Oh,
Thank
sorry.
Fine.
Something happened. Maybe the microphone switched.
Yeah. I will ask to the participants to close their microphone.
Oh, okay. Thank you very much.
Except to you, of course.
Okay. So I will continue about the family mediation, and it expanded rapidly. More than a third of all mediations involve family matters, and mandatory pretrial mediation introduced in 2020 has influenced how families approach the conflict. Lithuania's experience is not one of rapid transformation, but of gradual cultural change. A judiciary open to learn, legal practitioners adopted their expectations, and the society discovered that dispute resolution can occur not only in judgments but also in structured dialogue. With this context in mind, we can turn to the central question: can the development of amicable justice strengthen citizens' confidence in the judicial institution and in the rule of law? Across Europe, trust in public institutions shows a general downward trend. Courts remain comparatively well regarded, yet we increasingly observe skepticism. Citizens sometimes question whether judicial institutions truly listen or whether they simply process cases. They question whether justice is conducted with them or to them. Digitalization, despite its clear advantages, can contribute to a sense of distance. Remote hearings increase efficiency and accessibility, but they may take human interaction less direct. The courtroom became a screen, the judge became an image, and important nonverbal clues may be less visible. Technology is indispensable, yet it also introduces new forms of abstraction. At the same time, the nature of human conflicts has not changed. People continue to approach courts with concerns, expectations, frustrations, and sometimes anxiety. They seek not only legal remedies, but acknowledgement, the sense that their position has been genuinely considered. This is where amicable justice and mediation in particular provides added value. It does not replace judicial procedures, nor diminishes their importance. Rather, it complements them by offering a structured environment in which parties can articulate their interests, clarify misunderstandings, and potentially reach mutually acceptable solutions. Mediation can strengthen the procedural justice experience by enhancing participation, clarity, and perceived neutrality. A dimension that has gained prominence in European conversations in the contribution of amicable justice to judicial independence itself. When judge-mediator facilitate dialogue rather than impose outcome, they demonstrate that independence is not only structural, defined by constitutional guarantees, but also relational. It is exercised in service of citizens, not at a distance from them. This form of engagement reinforces the understanding that independent courts are not isolated bodies, but trustworthy, impartial stewards of conflict resolution. Such perceptions are essential for the rule of law, which depends on both institutional safeguards and public confidence. Lithuanian experience suggests that the efficiency and effectiveness of the mediation depends not solely on legal regulation, but on cultural readiness. As Peter Drucker observed, culture eats strategy for breakfast. Even the most sophisticated procedural framework will not be effective unless supported by professional commitment, societal and institutional culture. Conversely, when culture is responsive, even small-scale reforms can generate measurable results. Public trust in justice is multidimensional. Scholars such as Tom Taylor identify four core components shaping perceptions of procedural fairness: voice, the opportunity to participate in the hear and be heard; respectful treatment, being addressed with dignity; fair procedures, process perceived as neutral and consistent; and trustworthy authorities, institutions viewed as competent and honest. Court mediation, judicial mediation can strengthen each of these components. It offers parties meaningful participation, encourages respectful communication, improves transparency regarding expectations, and supports the perception of judges as impartial facilitators of problem solving. Moreover, amicable justice introduces that some scholars call deliberative legitimacy, the idea that the rule of law is strengthened when citizens feel they have meaningfully participated in resolving their dispute. This does not weaken judicial authority. It enriches it by showing that courts can integrate formal legality with human-centered processes, thereby broadening the ways in which legitimacy is experienced. The competence of mediators is crucial, central and crucial. Judge mediators serve both as neutral facilitators and as representatives of the judicial authority. Their ability to manage communication, identify underlying issues, and guide the process without imposing outcomes can contribute not only to trust in individual case, but to institutional trust more broadly. Judicial independence is not only structural, it also depends on public confidence, and amicable processes can reinforce that confidence when conducted professionally. Quality standards are therefore essential. Mediation that is rushed, poorly facilitated, or used as a mechanism of pressure undermines trust. Trainings, supervisions, peer reviews, and continuous professional developments of judges, mediators are critical in ensuring that mediation contributes positively to justice rather than detracting from it. At least we in Lithuania are working a lot in this field. Even unsuccessful mediations often improve subsequent litigation by clarifying issues and reducing conflict intensity. Amicable justice also contributes to the sustainability of the judicial independence by reducing systemic pressures. Courts across Europe face rising caseloads, societal complexity, and expectations of immediate responsiveness. Effective mediation helps courts deal with fewer backlog cases and gives judges more time to focus on disputes that truly need a full hearing adjudication. In the way, amicable justice acts as a safeguard. By reducing pressure on the system, it protects the courts from problems caused by overload, such as delays, public criticism, or outside efforts to control how judges work. Broadening the perspective, many European jurisdictions with strong mediation cultures, whether in the Nordic countries, the Netherlands, or Southern Europe, report high levels of procedural satisfaction. The Council of Europe, through CEPEJ, repeatedly highlights amicable justice as a factor contributing to trust. The European Commission's Rule of Law reports increasingly reference user-centered justice and multi-door court systems. Ultimately, the contribution of amicable justice to public trust lies in its ability to complement rather than substitute formal procedures. In an era of rapid digitalization and social complexity, mediation can increase accessibility, procedural understanding, and perceived fairness. It remains one tool, not the only one, in the wider framework of judicial legitimacy and the protection of the rule of law. Dear colleagues, what mediation shows, I think, is that trust doesn't arrive all at once. It grows slowly, like a plant you can't rush, no matter how hard you stare at it. Court built real legitimacy not only by delivering judgment, but by using procedures that are open, fair, and genuinely involving people. The judicial dialogue, including ours today, is very much part of this project and process. So instead of ending with a grand conclusion, let me extend an invitation. Let's keep exploring how amicable justice can find its place in our system, work hand in hand with the procedural guarantees, and grow into a practice that genuinely strengthens trust, judicial independence, and the rule of law. Thank you very much.
Amen, and thank you very much to you, dear colleague. And it is my great pleasure to introduce my good friend and colleague Anne-Marie Witters. She was just after me co-president of GEMME Belgium, and her day job is being judge at the Market Court, which is a specialized section of the Court of Appeal of Brussels. And she's also president of the so-called Chamber of Settlement in the Court of Appeal of Brussels. Dear colleague, dear Anne-Marie, the floor is yours.
Thank you very much to all the friends of EJTN, to all the friends of GEMME, particularly Avi and Frédéric, who I've seen online, and also, of course, to IGO, or the Judicial Training Institute. Let me start maybe by commenting briefly on the situation of mediation and conciliation in Belgium. And I'm very happy to announce that it is really flourishing. Let me explain to you first that professional judges like myself in Belgium are not allowed to act as mediators. They can refer cases to external mediators who are professionals trained to assist parties in an amicable settlement. But more importantly, professional judges are allowed and encouraged, since the law changed, thanks to my friend Avi in 2018, they are encouraged to act as conciliators, and judges increasingly do so. They do so, and this has been going on for a couple of years already in family law. That's the area where amicable dispute resolution was first developed in Belgium. But now it is slowly moving on to all civil law in the broad sense of the term, to commercial law and to employment law, and very recently also to cases involving the authorities. So I think I can proudly say that Belgium is really a growing area and territory for amicable dispute resolution. It has grown organically, but the legislator did help us. In 2015, he encouraged mediation in family law. 2018, mediation in civil and commercial law by embodying it in a legal framework. And most importantly, since December of 2023, the law has obliged, and it's really an obligation, all courts and tribunals in Belgium to have at least one chamber for amicable dispute resolution. And this has to be done had to be done by the 1st of September 2025. And it is a fact now that all courts and tribunals in Belgium have a chamber for amicable dispute resolution with trained judges. Thanks to, again, the efforts of IGO and many, many volunteers in the field. This as a short summary of the situation in Belgium. We can discuss it later on if you'd like. I would like to project my PowerPoint to deal with the topic that I've been given today. Let me see if it works. Yeah, it should work. I hope you can see it. Is it visible for everyone?
Yes.
Okay, let's start. So the topic I've been asked to present to you today is a very interesting topic, at least from my perspective, because it deals with a very hot topic of today, being the digitization of the justice system. And there, sadly to say, you will see our courtroom on the screen. Belgium is not in the forefront of digitization of the justice system, but I have thought about the problem. And at the Market Court, we are dealing with digitization in a very quick manner. And we are changing from our traditional methods of resolving disputes face-to-face with the judges, as you can see them on the screen, with manual procedures and records kept in paper. And we are evolving, especially since the COVID-19 pandemic, to technology. What does it mean, technology? It means that we can have virtual judges. It means that we can have artificial intelligence infiltrating in mediation or conciliation systems, including but not limited to online dispute resolution platforms. And it even means that we can have artificial intelligence-based prediction tools enabling, for instance, parties in a mediation to better do their own reality testing with their legal advisors. So if we look at whether digitization of justice can mean that we strengthen the role of judges in ADR, my short answer is yes, but there are a number of conditions. First, maybe a brief explanation about what I mean with digitization and digitalization. Digitalization for me is what we are doing now, the conversion from analog to digital data. And this is what we are doing all the courts and tribunals in Belgium. Digitalization is going a bit further. It means adopting and adapting digital processes. We are doing that in some courts and tribunals, but we are not very well advanced with it yet. And at the end of the chain, we will hopefully have a digital transformation. And there we start creative processes. We are in Belgium not there yet, but we are moving fast toward this goal. You will see on the next slide certain categories of technologies and how we use them in the courts. We use technology for case management, for virtual courts, for machine learning, in order to ensure public access to courts, e-filing and online forms. We use them for statistics, and we use them for different apps. And you all undoubtedly use them also for various purposes in the courts. What are the advantages of the digitization of justice? Advantages are clear. We will have more streamlined processes. A lot of our politicians say we will have more efficiency. Let's see about that. We may have less cost, but we may have also a justice that is more accessible. But digitization for me also has a number of deep questions and maybe even downfalls. What about fairness in the process? What about public trust in the system? Is there enough room for nuance? What about transparency and about accountability? So yes, we should embrace it, but we should not be naive. If we look at alternative or amicable dispute resolution or efficient dispute resolution, as we say sometimes, I would like to go to the words of Professor Richard Susskind from Oxford, very well-known professor, who has been publishing greatly about online dispute resolution and about the changing roles of lawyers and judges in the future. And what he says is very important. Machines don't replace mediators, they augment them. By handling the repetitive and data-heavy tasks, artificial intelligence allows professionals to focus on what they do best, and there it's very important: human judgment and empathy. For instance, if we have artificial intelligence-driven tools, they can help us to identify patterns in similar disputes, offering mediators or judges a roadmap for resolution strategies. Online dispute resolution platforms like Modria and Matterhorn are bridging gaps in access to justice by offering low-cost and user-friendly solutions for resolving disputes. These platforms have shown to be particularly effective for small claims, for consumer disputes, employment issues, where traditional mediation or ADR, amicable dispute resolution, might be cost prohibitive. So while technology brings undeniable benefit, it also raises important ethical and practical questions. For instance, how do we ensure confidentiality in virtual mediations? What safeguards do we have in place in order to prevent artificial intelligence bias or hallucinations? Well, I believe that ADR professionals, which we are, mediators, conciliators, and judges, we must balance technological innovation with the core principles of fairness, neutrality, and confidentiality. How do we do this? And there I have three proposals. And the first one is to put the human element of ADR in the forefront. And the human element of ADR, or amicable dispute resolution, is very clearly empathy, creativity, and trust. Technology in ADR isn't a trend, it is a transformation. By leveraging these advancements thoughtfully, we can make mediation and conciliation more efficient, more accessible, and even more impactful than ever. Technology is not merely an add-on in dispute resolution, it is, in my opinion, a catalyst for its evolution. As ADR professionals, lawyers, judges, mediators, and conciliators, we must stay informed, we must adapt to these new tools, and ensure these advancements are used to uphold the principles that make mediation and conciliation effective. So my first proposal is to keep the human element of ADR in the forefront. The second proposal I wish to make today is that the role of judges in amicable dispute resolution must even be more reinforced. The future of justice, increasingly, as we know, lies outside the confines of a traditional physical courtroom. Courts should be viewed not as fixed locations, but as services that are robust, easily accessible, transparent, widespread, and outcome-driven. I like to call this the multi-door courthouse. But in order to reach this objective, we need to increase the number of trained professionals. We need to expand the range of institutions offering training and establishing standardized training requirements, and those are effective ways to enhance capacity without compromising quality. And these training programs, in my opinion, should combine simulated ethical training, best practices, and real-world experience to ensure high-quality service. However, enhancing human resource capacity goes beyond merely increasing the number of trained neutrals, mediators, judges, conciliators. We also need to look at other critical players, such as, for instance, judicial court officers, court registry staff, and even volunteer paralegals. We are actually, in our court, we are doing a pilot in training paralegals in mediation and conciliation tactics. Tailored training programs must be developed for each of these stakeholders to ensure that they are also fully equipped for a future in which technological advancement is key. So my second proposal is indeed to reinforce the role of the judges in amicable dispute resolution. The third proposal I wish to make today is that the government and the judiciary need to set a strong example. How do we do this? We do this by increasing public confidence in mediation and conciliation, and this will grow if mediation and conciliation are used often in government-related litigation. This has started now in Belgium, and it really increases, its success increases the trust in mediation and conciliation from various actors. So I think this is the way to go forward in the future, government setting an example. Cooperation between the government and the judiciary can also facilitate the integration of ADR into court-affiliated centers, where, for instance, artificial intelligence or other technologies can be especially useful in resolving low complexity cases efficiently. The first focus should be on strengthening the existing legal framework for alternative dispute resolution and make necessary amendments for online dispute resolution. Secondly, I think we need a light touch regulatory approach to be adopted with voluntary guidelines or principles that ADR service providers must follow. Ethical principles for alternative dispute resolution centers and third-party neutrals, and design principles for online dispute resolution platforms. ADR indeed represents the future of conflict resolution because it offers an innovative and efficient alternative to traditional courtroom procedures. So the government and the judiciary, in my opinion, must collaborate with all the sector providers to build capacity and foster innovation. And the government, and this is my third principle, must set an example in this. How to achieve the final stage of the digital transformation that I described in the first slides? I think there are some important principles that we need to keep in mind. We need to identify the people who are excluded or left behind. We need to proactively integrate 3 easy to use adaptive technologies, and accommodations that support persons with disabilities and linguistic minorities to receive independent access to alternative dispute resolution. And we need to transition carefully and slowly, ensuring continuity of alternative dispute resolution for all. Focus initiatives on people-centered and not system-centered transformation, and keep the independence of judges and mediators as primary concern. We need, and this is my final remark, we need, but it's very important, I deal with data protection in the market court, we need to protect the data. Scrutinize the data on which digital technologies, particularly machine learning or artificial intelligence systems are built, and alert to embedded bias. We need to require human oversight of machine learning infrastructure and ensure that all case and personal data is isolated from government control. So I think before we reach the strategic transformation, there is still some work to be done. But I do believe, maybe I am too much of a believer, but I would like to be one, that strengthening the role of judges in the search for amicable resolutions is compatible with the digitization of the justice system, but always with conditions, as I mentioned before. Thank you very much, and I'm available for questions or remarks after this presentation.
Thank you very much, dear Marie. Fascinating indeed. Well, for the 10 next minutes or so, the floor is yours, dear participants. Who wants to, I see, Mrs. Floortje Buysens, please turn on your microphone and you have the floor. Did you upload or did you want to speak? No, I think.
She uploaded.
Oh, she uploaded and didn't want to speak. All right. Anybody wants to say something, remark, question, suggestion?